pretty significant number of fan games have been hit with cease and desist letters in the last few years. Let's chat about why in the comments, but first, my opinion. I'm Tarmack, and this is Feature Creep. Pokemon Uranium and Prism, a remake of Castlevania and Unreal, AM2R, the WoW Nostalgia server who fled to another known fan server called Elysium but has since backpedaled, Doom RL, sort of, the Chrono Trigger Crimson Echoes sequel, and of course the infamous Project M, among so many more, have been shut down or significantly changed because of these mysterious cease and desist letters, which is usually a precursor to a lawsuit on the grounds of copyright or trademark infringement. All of these and many, many more have been shuttered over the years. A long time ago, I was part of a Lord of the Rings mod group attempting to recreate Middle-earth in Neverwinter Nights. That group shut down over mostly infighting between the purists and those who actually wanted to get the server up and running at some point, but if that hadn't happened, we would have been shut down by the Tolkien estate once they became aware of us. This tricky mire, it turns out, isn't quite as tricky as some would like to believe, and at least on the question of whether a fan game is legal or not. Before I get too far into this, I need to make a very important distinction and preface it by saying that I'm not a lawyer. I'm just someone who makes agreements for a living and I read a hell of a lot. There's a difference between copyright and trademark, and for the most part, I'm going to reference US copyright and trademark law. Copyright is a section of law designed primarily to protect the person or entity that has created something from someone else illegitimately profiting or denying the creator profit of their work. It's a protection mechanism for the creator. When we're talking about copyright, that usually means things like poetry, books, musical creations, artwork like paintings or sculptures, TV shows, movies, blueprint designs, and video games. Now, video games, of course, incorporate multiple types of things as part of the copyright whole, including written dialogue, visual art, audio tracks, and such. This is not an exhaustive list, but you get the idea. It's also worth mentioning that fair use, under copyright law, is an exception that allows you to use copyrighted material without permission under somewhat broad but well-defined circumstances. A news broadcast, for example, Nintendo, or, say, a product review. Trademark, on the other hand, is totally different. Trademark is designed to protect the consumer. A trademark is something obviously recognizable that lets the consumer know that a product, service, or such is legitimate. I know that when I buy a vacuum with the Dyson logo, I'm buying a decent but way overpriced vacuum cleaner, and that it's a legitimate item produced by the company I intended to buy from. It identifies the brand owner. And fair use under trademark law, while it does exist, is primarily to handle situations like Apple, where an already commonly used word becomes trademarked or receives a, quote, secondary meaning, end quote. It's also used as a way to reference the actual trademark product or owner, usually for product criticism purposes. The same level of fair use afforded under copyright isn't quite there with trademark, and with trademark law, one of the biggest qualifiers is that the use is such that no consumer confusion is likely to occur. And this is where trademark and copyright often begin to get confused. Is Mario a trademark? Well, no, the name certainly isn't. Mario's a common name, many people have it. So you can go ahead and make a game with a character named Mario in it. But if your character also happens to wear blue overalls, have a mustache, a hat with an M, and say, "It's me, Mario," okay, now you've begun to very seriously infringe upon the trademark of Mario that is owned by Nintendo. Would a character in Grand Theft Auto 5 that wears realistic blue overalls named Mario infringe if he shared little else in common? Probably not, and that sliding scale is one that people have a difficult time squaring, which is one reason why lawyers exist and get paid the big bucks. But Mario is also a copyright when he's in a Nintendo video game and I use a piece of footage of that game in a YouTube video, which is why these two legal terms are very confusing to people. Again, I'm not a lawyer, but you can look this stuff up yourself as well if you feel like verifying what I'm saying. You don't need to dig very deep into copyright and trademark law to learn most of this. Remember how I said that copyright law exists to protect the creator, but trademark exists to protect the consumer? Well, one of the requirements of owning a trademark is that you protect it. Per US trademark law, and just let me get through this for posterity and those who want to fact check me, US Code Title 15, Chapter 22, Subchapter 1, Section 1064, and I'm not going to quote it for fear of putting you to sleep, but essentially, a petition to cancel a registration of a mark can be submitted by anyone who is subject to civil action for infringing upon that trademark. And it comes with some qualifications. The biggest one, which deals with what we're talking about here, is the third qualification that talks about the registered mark becoming the generic name for the goods or services. So, if you're being sued for trademark infringement, you can file a petition that the trademark is too generic. with accompanying evidence, of course, and the court can cancel the company's trademark if it agrees with you. Have you ever heard of a thermos? How about a trampoline? Or one of the biggest ones, aspirin? These were all at one time owned trademarks. Hell, go swing by the Wikipedia page and read the story about genericization of the trademark heroin. It's an interesting read. The problem? These all became generic in the public eye that to the average Joe or Jane, every bouncy platform was a trampoline. Every acetylsalicylic acid pill was an aspirin. Why do you think Google fought so hard to stop people from Googling things on the internet and instead search Google for them? Or, more on topic, Nintendo fighting tooth and nail to stop people from calling every game system a Nintendo back in the 90s. Good chance your grandparents still call your Xbox or PlayStation a Nintendo. It's because of that termination clause in trademark law that says you can lose your trademark if it becomes generic. This fear absolutely permeates business. Every company is terrified of losing their brand, their trademark, despite there being little chance that a tiny fan game enjoyed by a few thousand or tens of thousands of people would actually genericize their registered marks. And while I know some very good and very ethical lawyers, it doesn't take long to capitalize on that fear and make the entire corporate world very protective of their branding. Of course, it's also worth mentioning that while no single paper cut is enough to kill, several hundreds or thousands could certainly do the job. So while protecting their trademarks against what we in the consumer market perceive as minor examples, you have to consider that many of these companies could well be fighting hundreds of trademark infringements every year. We only ever hear about a few of them, just like we only ever hear of the few of the great games that come out every year. So if you, as a burgeoning developer, decide to embark on a game project that's not just inspired by, but an actual fan project of a well-known, or frankly, not so well-known intellectual property, these are the kinds of things that you should educate yourself on. The simple basics of copyright and trademark law is that in order to produce anything that uses trademarks or copyrighted material of somebody else, you need the permission of the owner. I've heard arguments that depending on how it's built, a fan game could be an application of fair use. And I suppose I see some of the logic there. But you still haven't dealt with the trademarked elephant in the room. Not to mention just how much ad and donation revenue a well-known fan game can bring in, which isn't technically selling anything and thus totally okay if you believe internet logic, but is unlikely to help your chances in a copyright or trademark infringement lawsuit. A question that I think is fair to ask is, why does your project need to be a fan game in the first place? What would be so wrong with making a game called Animal Catchers, where you walk around in a top-down world with blocky buildings, catching funky-looking critters in the grass and battling them against one another? Or, to give a more direct example, take a look at Harvest Moon and Stardew Valley. Why do people build fan games when originals of the same kind would be totally fine from a legal perspective? Clearly, it starts with the love of the franchise, but it's also hard to come up with original artwork, and it's even harder to get people to care about your project without the big official name attached. And that, friends, is kind of the whole point of trademark. You're leveraging the success of a company that has spent huge sums of money on their brand, and you're taking advantage of their brand recognition. That's precisely why it's trademark infringement, and why it's never going to be okay from a civil litigation standpoint. And I totally get the community love of fan games. I played Pac-Man Wolfenstein back in the day, and like I said, I was in a Lord of the Rings mod remake group too. But the primary issue here comes back to trademark as a consumer protection mechanism. It's not hard to see why the moment they know you exist is the moment that you don't anymore. Usually, right about now, a point that is commonly brought out is, why don't the companies just offer a license to the fan game group? Well, why should they? Does the fan game have quality standards? Do they have legal representation making sure that no other copyrighted assets are in the game that the licensing company is now attaching to their brand? Do they have a solid development pedigree? Is the fan project going to cannibalize sales of your official product? Will it reflect well on you as a company to have this fan project be considered officially licensed material? The reasons why a company should not license their IP out to every Tom, Dick, and Harry out in the wild far outweigh the reasons that they should. Just because you saw one that looked good doesn't in any way mean that project should have been officially supported. And you know what? After all of that ranting, some companies do license out their IP. That's how we get licensed games like Double Fine remakes of Monkey Island and Day of the Tentacle. And despite all of the business oversight that comes along with those kinds of titles, we still get shitty ones from many developers. Is that going to be better if it's just a bunch of people doing the fan mod in their spare time? There might be a couple of gems, but I think gamers know better than that. I will say that there's one company in particular that I want to talk about though on the front of fan-made games, and I want to point out just how dangerous this situation is. Sega seems to have a pretty easygoing view of these fan projects, at least until they decide that's no longer how they want to operate. The official Sonic the Hedgehog YouTube channel made a joke about a DMCA takedown, following it with, quote, "Just kidding, keep making great stuff, Sonic fans," end quote. This is dangerous for two reasons. First, it isn't explicitly giving permission for fan projects, rather is implicit, which, given my own history with drafting agreements, tends to be the tactic of a group that isn't willing to commit to something. And second, it's not a license to make fan content, but rather a very generic statement about great stuff, which could easily be rescinded at any time. That's particularly dangerous because someone could take it for permission to proceed, only to have Sega decide later that they need to shut down the fan project, which could easily end with someone who was just an ardent fan losing their house. This also applies to the common internet wisdom that says don't announce your fan game until you're ready to release, because then they can't hit you with a cease and desist letter and the game gets released and out into the public. As though the cease and desist, not the post-launch lawsuit, is the real problem of the day. And the best part, you'll never know, because in a case of clear trademark infringement, it's very common for the final settlement to be under strict NDA. To quote a tweet from Ryan Morrison, aka Video Game Attorney, quote, "You won't hear about life-ruining lawsuits. 99% of the time they settle, but still ruin the life. And part of the settlement is an NDA." End quote. A fan game is a wonderful concept, and when put together by a skilled team can be a hell of a lot of fun to play. But there are hazards in the water that you're going to run into, and those terribly nasty big corporate IP holders, they're not out there to stomp on the little guy just for the fun of it. They just have to exist within the trademark law that protects all of us from counterfeit products so that when we buy a game that says Pokemon, Doom, Mario, and such, we know it's legit. You can try to come up with all of the logical reasoning that you want about how fair use applies or how Sega once said it's kosher, but the fact of the matter is that these do not protect you. I love a solid fan mod or a full-on fan-made game just as much as the next person, but there isn't a clean way for companies to do this kind of thing long-term, and I think that the just license it nonsense is precisely that, misinformed, ill-conceived nonsense. Fan games are not okay, as much as part of me wishes that they were, but our entire consumer product mindset is predicated on trademark working as intended, so I can't really even get behind that horse. Every fan game that you hear about, frankly, you should expect to get shut down, which is sad, but I think there's a silver lining. If you and your team are skilled enough to make a great fan game, then you're skilled enough to make the next Stardew Valley. So why not go down that road and try to drown out the flood of trash games we've had over the last few years? Frankly, I think that gamers will thank you for it. What do you think of fan remakes? Personally, I think they can be great, and I also think that it really sucks when some of the most over-the-top fans of a game get essentially the criminal treatment. Let's chat about it in the comments. Feature Creep is a regular show, and I do other stuff which you can check out on the channel or, hey, over on Twitch. Discord is fun for chatting with people who watch my stuff, or just people who stumble in and forget to leave. Link to the chat room is in the description. Thanks for watching. That's all I have to say. Tarmack out.